This video will help you understand which estate planning documents are crucial for you to have. If you don't know who I am, my name is Chris Dime. I'm a financial planner out of Edmonds, Washington, and I specialize in working with folks to and through retirement. As any good holistic financial plan is concerned, estate planning is a core component. Now, I know what you might be thinking. Estate planning doesn't really apply to me. I might have some kiddos and some assets, but I don't have millions and millions and millions of dollars. Well, hear me out. Even if you have millions of dollars, or you just have dollars of dollars, it could still make sense to implement an estate plan, and that could be by way of just a couple of documents. Now, rather than dive into the minutia myself, we had a chance to sit down with Kanoa Ostrem, who runs an estate planning practice out of Seattle, Washington, who does this all day long. And Kanoa is actually someone I've referred a number of my clients to with success, and I figured he'd be in a much better position to share, based on where you're at in your life, which documents would be in your best interest to look at implementing. So without further ado, here's my interview with Kanoa. Enjoy. Okay, so hey, Kanoa, glad you could join us today. I figured it would be helpful for the audience to give just a brief overview of what goes into a general estate plan. And I know we've had some success working together in the past with some cases. So maybe you could start off with just a brief introduction. Who are you, and why should people listen to you?
Yeah, so I'm an estate planning attorney. I've been doing this for about 25 years, and this is all I do, helping people with wills, trusts, powers of attorney, healthcare directives. And many people come to me and say, I don't have anything, what do I need to do? Or they say, I've got existing documents, can you review these and update these? And so we just tend to help people through that process, basically.
Gotcha. And then what would go into sort of like a basic estate plan? So someone comes into you, comes into your practice totally new, they don't have anything in place. What typically do you recommend to them?
Yeah, so every adult in Washington should, first of all, have a medical power of attorney. That's a document that says if I'm unable to make my own medical decisions, this is the person I want to be in charge. And that's very important because if you don't have one, under HIPAA, your doctors can't really talk to anybody. Someone may have to go to court to have a guardian appointed for you, which can take a long time and be very expensive. So we don't want that. So you just have a medical power of attorney, you appoint the right people to be in charge, and then that's just covered. You solve that problem. So first off, everybody should have a medical power of attorney. And then related to that, most people do also sign a healthcare directive, otherwise known as living will. You don't have to have one, but it's a good idea to at least take a look and see if you want to sign one. It's basically a document that says that if you're unable to make decisions, essentially you're unconscious, you're near the end of life, it's thought that you're not going to recover. It's a document that says that you don't want to be in a permanent coma, that it's okay to let you pass naturally. So those are the two healthcare documents that pretty much every adult, has in Washington. Medical power of attorney, mandatory. Healthcare directive, advisable, but you don't have to have one if you're not comfortable, because the medical power of attorney could make that decision for you if you don't have a healthcare directive. So those are the two healthcare documents. And then the third document is a financial power of attorney. That's the person who would pay your bills, manage finances, work with your wealth advisor if you're unable to manage things. So it's for someone to step into your shoes financially. And again, we want to avoid having a guardianship proceeding, which is what happens if you don't have a financial power of attorney. Your accounts can't be accessed by some third party, so your family has to go to court to have a guardian appointed, which is a nightmare. So instead, you just have a financial power of attorney. You say, this is the person in charge if I become unable to manage things, and then that's just handled privately, nice and easy. And so those three documents, pretty straightforward and important. The fourth document is a will. Most people in Washington just have a will. They don't have a revocable living trust, which would be a fifth document that you could have. But the fourth document is a will, and that obviously disposes of your assets and puts the right people in charge. And those are very, common in Washington because our probate process in Washington is really not that bad at all. It's a very unique state when it comes to probate. So most people just use wills and don't go to the extra step of having that fifth document, a revocable living trust, which pretty much everybody in California would have. Oregon, Hawaii, many states, it's really advisable to use a revocable living trust. In Washington, they're not really as necessary unless you have out-of-state property or a need for a higher level of privacy. So they're fine. You can have a revocable living trust here. They're just not needed as urgently for most people as they are in other states.
Yeah, because you hear horror stories about, probate and things getting jammed up in the process. And it sounds like
a revocable living trust could be really additive and helping lubricate that, proceeding and, help people get the assets that, maybe they need, especially if they're kiddos or something of a recently deceased parent, right?
Yeah, so it can make things a little bit faster when someone dies. Say it solves a step, but it doesn't really provide any extra tax planning or asset protection planning. It really just avoids probate, which is a pretty small problem in Washington, which is why most people here just have wills. Like I said, it's fine to have a trust. It's just it may be overkill for a lot of people. You may be able to save some money by not having that fifth document and just having the core four documents. And your will can do a lot. So your will typically would have some trusts come into effect upon death. So we call those testamentary trusts. So it's very common for you to have a will that says, when I die, I'm going to leave a trust for my children. And that just gets created upon death under the terms of your will. Or if you have a partner or a spouse, if I die first, I'm going to leave my partner or my spouse a trust to minimize estate taxes, provide some asset protection, and then make sure everything passes on down to the right beneficiaries at the next level. So trusts within a will are very, very common in Washington, and a lot of the meetings focus on discussing that because of the tax part, which is a little complicated, and the asset protection part, which is very important as well. So we spend a lot of our time talking about those trusts that are set up within your will.
And so, like, let's say someone, comes to the office and maybe they did some of that estate planning a couple of years ago. And how would you go about deciding whether or not someone should, scrap it all and just re-up a brand new estate planning package of the documents you mentioned, or if they should do like some slight adjustments? And is the terminology like a codicil? Is that correct? If they want to make adjustments to their estate planning documents?
Yeah. So codicil is when you just make an amendment to a will that's kind of a shorter document to just make one small change. It is also pretty easy to just draft new documents because it can be less time to just work with the documents that you've already figured out for that type of situation and the template that we have. Oftentimes it's faster to just create new documents and it's nice and clean. Codicil refers to an old document that may need several changes, and it can be more work to do a codicil than to just prepare a new will. So oftentimes, not just me, but any attorney, you're just drafting new documents, and it doesn't mean way more work. Oftentimes it's less work to create new wills. But, oftentimes people come to us, they say, hey, review the documents we do, and they look great. There are a lot of good attorneys in Washington. So oftentimes the documents look great. And so we say, no, they look great, carry on. Or, well, your net worth has gone up quite a bit. Maybe we need a little bit of tax planning here. Your son's a doctor. Your son would probably want to inherit a trust because of the asset protection feature. So just as life changes, oftentimes there are things that will change in the plan, and it's not that hard to just create those documents to address your current situation.
So I've heard in the estate planning space some back and forth on whether someone should set up a revocable living trust, as you alluded to, ahead of time, or if they should just rely on the testamentary trusts that are dictated in their will to get established for their family. I guess, which camp would you fall in? Like, if someone has the money, should they just pay to get that revocable living trust set up? Because the argument goes that, on the testamentary side, you're going to have to hire an attorney to set up the trust at that point anyways. So you're kind of paying the hourly rate regardless. What are your thoughts?
So in Washington, when you have a good will and all your properties in Washington, there's not that big of a difference as to what you have to do when someone dies. With a will going through probate, nobody goes to court. You mail some documents into court, you get a court order back, and you proceed as if you had a revocable living trust. So it's really not that different of a procedure to go through probate as long as all your assets are in Washington. If you have a home in California or somewhere else, then you need to have a trust. And if you want privacy, a trust is more private. So if there's something in your plan you wouldn't want someone to be able to discover, then you need to have a trust. But really, most people end up choosing to just have wills. We offer people both. We say, look, it's going to cost this much to have an estate plan with wills. It's this much more if you want to have a revocable living trust. That's fine. Just know you're going to spend, $1,000 more. Or if you have a lot of properties, then it could be several thousand more because deed filing fees are not cheap, and you have to get deeds prepared. So it can cost a few $1,000s more to have a revocable living trust. Not a tremendous savings at the end if all of your property is in Washington. So a lot of people just decide to have wills. And so I just leave it up give them both options, let people know the pros and cons, and then they can decide which they'd have. You're not making a mistake either way, but you may want to save a little bit of money now and have wills, or you say, hey, no, I'm going to be super proactive and get ahead of this and spend a little bit more and have trust, and that's fine too.
Maybe one of the mistakes you've seen other folks execute in the estate planning space is getting the trust drafted and things, but maybe not funding that by following through with the deed and whatnot.
Exactly, yeah. So if you don't fully fund the trust, then you're still going to go through probate. And so then it wasn't really money well spent. So if you do proceed with the trust, take it seriously, make sure that you get it fully funded, really listen to the instructions you're given about retitling your accounts.
So you touched on kind of in general, the documents that pretty much everybody should look to execute as part of their estate plan. What about some like special circumstances? So like I work with a lot of families that have, loved ones with special needs, blended families, maybe there's been a few marriages in the past. Maybe help us understand in some unique circumstances, maybe some other documents they'd want to be thinking about.
Yeah, so trusts are great for that. So very common estate plan is we have a couple that's married, or they're not married, but they're a couple and they've got kids or nieces and nephews that are going to be their ultimate beneficiaries. And so their wills or their living trust will say, upon the first death, let's create a trust for the surviving spouse or the surviving partner. And that trust can be set up in a way so that you're taking good care of that surviving spouse or partner. They can be the trustee and have very, very broad access to the money, but typically their new spouse won't be a potential beneficiary. So you can make sure it's only going to benefit the people you want to benefit and not a future spouse. And that trust would be protected from lawsuits. If the surviving spouse or partner were involved in a car accident or a bad business deal, a trust is protected from lawsuits. And then if the survivor ends up in a nursing home late in life in a Medicaid spend down situation, the trust can be converted into a special needs trust so that it doesn't all have to be spent down to zero before you can get on Medicaid. So using trusts for a spouse or partner is very common these days for all those reasons. There's not a big downside to that. And then, with the next level of beneficiary, same thing. If it's a child with special needs, again, the trust that we set up, typically there's a clause that says, hey, if it's best for this child, this trust can become a special needs trust. And so the child's not disqualified from getting government assistance, or it can remain as just kind of a standard trust that's going to provide for help with a down payment on a house and education and healthcare and some money for travel and a certain amount towards a wedding. Trust can be very specific about the ways that you want to benefit any given beneficiary given their circumstances. And you just need to give it some thought and be open to those ideas that are presented to you. And then you can really, solve all those issues that may be, giving you concern about, especially like a special needs child or someone your child has been divorced twice. The trust can basically solve those problems.
Or maybe a kiddo that's been, married once, but for one reason or another, you're not the biggest fan of their spouse.
Yeah. Use a trust. Yeah. And that can just cover it.
We oftentimes hear about folks saying, oh yeah, we use trust, and there's a certain level of like mystique that I think people, use as a cocktail hour conversation on, I have a trust or my family trust, etc. And a lot of times they're referring to like tax benefits and unique qualifications with trust. Can you maybe help for the audience understand, like when people are saying, hey, trusts help from a tax perspective, what maybe they're referring to there?
If it's a revocable living trust that you set up for yourself, that does not do any extra tax planning or asset protection planning that you cannot do in a will. So a will and a living trust are exactly the same, except that a revocable living trust avoids probate. Like I said, in Washington, that's not that big of a deal. In many other states, it is. So everybody has a revocable living trust. So we get that a lot. My neighbor says, I have to have a revocable living trust. And we have to tell people, look, you don't have to in Washington. We're a unique state. Wills work fine. You can have a trust. It costs a little bit more, and that's fine. Where the real asset protection and estate tax savings come from is not from a revocable living trust, but from an irrevocable trust that is set up under the terms of your will or set up under the terms of your revocable living trust, or is just a separate standalone trust. So for example, you have some stock that you think is going to greatly appreciate. You've got a large estate. You're worried about, hey, my estate just keeps growing and growing. I want to get some money to my kids. In that case, we set up irrevocable trust for the kids. And you give the stock to the trust before the stock depreciates, or even after it depreciates, but get it out of your estate, get it into those trusts. And if your kids get divorced, it's protected. If your kids are involved in a lawsuit, it's protected. If your kids are too young to get the money and you want it to be just held and invested, the trustee is going to do that. So you can, still protect the trust assets from third parties and from the youth of, beneficiaries who are not ready to have access yet. So irrevocable trusts, standalone for gifting, those work great. Under the terms of your will, leaving one to your spouse or to your children, it has to become irrevocable, because if it's not irrevocable, if they can revoke it, it's not protected from lawsuits. It's not protected from divorce. So it has to be an irrevocable trust, which sounds scary to a lot of people, but a trust can be irrevocable and be generous. So it doesn't have to be a strict irrevocable trust. Like the trust you leave your spouse or an adult child typically is an irrevocable trust that is where the beneficiary is the trustee and they have broad access to the money. So they're going to not really feel like they're being micromanaged, yet they get these protections from third parties if it's set up properly.
Yeah, I think people hear, words like irrevocable, and obviously that brings some anxiety, like I'm making a permanent decision. And then they hear horror stories like, the old Britney Spears saga thing where, she had a bunch of money, but she wasn't in control of her own money. And so that led to a whole bunch of scandal. And I think, that causes concern for a lot of people when thinking about, whether or not they want to make an irrevocable transfer to some trust they can't amend, Yeah.
And so you should, anytime you see irrevocable in the title of a trust or it's discussed that way, you want to be very careful about the terms. You want to make sure the right trustee is in charge and that the right flexibility is there. Or in some cases, it needs to be strict. If it's for someone who's not good with money, sometimes it has to be strict. So it just has to be appropriate for the situation and well thought out. But it's not usually that hard to get to that point as long as you put a little bit of thought into it.
And so it sounds like, if I'm hearing you correctly, the irrevocable trust, like the main value of that from a tax standpoint is if you are approaching those, federal estate tax levels, or you forecast with whatever concentrated stock or, closely held business, ownership you have, that will appreciate to something well and above the federal exemption levels, which I think for now are like 14 million, right, per person. And then kind of in 2026, it's forecasted to be somewhere closer to like 7 per person.
Exactly. Yeah.
Gotcha. So if someone forecasts themselves being there, maybe it would make some sense to look more into the irrevocable nature of a trust.
Yeah. Or if you don't want to pay the Washington estate tax. So in Washington, we have our own estate tax with a $2.2 million exemption. So a lot of people are over that exemption and they don't want to pay that tax. So we're planning for that a lot. And so one thing that people don't realize is if you plan well, help your parents plan well, you can really save estate taxes in your own estate. So people will have a client say, hey, by the way, my mom is 95. I'm her only heir. She's got an estate of like $5 million. Is there anything I should do? And I say, yeah, absolutely. You have your own taxable estate. I've worked with you and I know you've got substantial assets of your own. We don't want to add her $5 million into your estate, nor do we really want her to skip you and give it to your kids. So your mom should leave you an irrevocable trust. Her will or her trust can set up an irrevocable trust for you, where you're the trustee, you're the beneficiary, you can use it for your family, but you don't directly own the trust asset, so it's not a part of your estate. So when parent leaves it to child, and then child has access to it, and then when child dies, it's not subject to estate tax. That's how we get around the Washington estate tax. It's really easy if your parents just have that tip and update their plans to leave you a trust like that.
That kind of raises a flag of the generation skipping transfer tax stuff. How does that apply? Do you have familiarity with how that works?
Yeah, so that is a generation skipping trust. So a generation skipping trust is a trust that may last for more than one generation. It doesn't necessarily skip the beneficiaries. So that's something that people have that misconception is that, well, I don't want my parents to set up a trust that's going to skip me. Common situation is people have a large estate. They're going to leave it on down to their kids in trust. And we set that up as a GST trust, a generation skipping trust. So a generation skipping trust doesn't necessarily not benefit the next generation. It doesn't necessarily have to skip and go all the way down to the grandkids. It just skips estate taxes. So you leave a trust for the benefit of your children, and that trust just lasts for their lifetime and never just distributes everything out to them. It lasts for their lifetime. And then if it has the right provisions, when the children die, It's not subject to estate tax. It's going to continue on tax-free for the benefit of the grandkids. And that trust can last even for their lifetime. So a trust like that can last for up to 150 years. We don't think most trusts are going to last that long. It's most common that a trust will last down to the grandkids and maybe help the grandkids buy a house in Seattle or Bellevue. It's great if you can do that much with a trust. But yeah, GST trusts are very common because you can avoid tax at the second generation, which is a big deal. When you have that $2.2 million Washington estate tax exemption, a lot of people are bumping up against that. So GST trusts are very, very popular.
Yeah, I'd imagine like the concern there is, grandparents pass away, they give a bunch of money to the kiddos. The kiddos may or may not need all of it, but probably not if they're well, positioned. And then, the grandparents paid estate tax, the kiddos then pay estate tax, and then the grandkids get the money. So
yeah. So we avoid that one level of estate tax by just being smart about how the grandparents set up their plan.
So then I guess last question on the unique financial planning concept in the estate planning space. In the past, I've heard estate planning strategies like defective trusts or intentionally defective grantor trusts. Those were kind of like all the rage on financial social media a couple years ago. What's your 2 cents on that? How should people contextualize that?
Yeah, intentionally defective trusts sound terrible, but they're actually great and they're very common. It's just when you set up a trust while you're still alive. I set up a trust for my kids. I put some stock or some real estate into the trust, and the trust is set up on purpose. That's why it's called intentionally defective. Defective in meaning that the income taxes are still treated as my responsibility. So I set up a trust for my kids. I put assets in there. If those assets generate income, that income is actually going to flow back to me. I will pay the income tax. The trust does not have to pay income tax. So we do that because then the trust doesn't need a tax return. So it's nice to minimize that accounting. And then also then the trust is just growing without the drag of income taxes. And I can pay the tax with my assets. And then we let the trust grow basically income tax free. Don't let that word scare you off. It's actually how trusts should usually be set up when they're gifting trusts. Intentionally defective grantor trust.
Yeah, it sounds like something went wrong in the plan, but it sounds like you're reassuring that if someone recommends that, they probably know what they're talking about. Okay.
Yeah. It's a good deal.
All right. So as we get ready to wrap up, just I guess a couple more questions. The one of the biggest ones I run into is folks that might see the sticker shock of like a $2,000, $3,000, $4,000 estate planning engagement to work with somebody, and so there's a lot of these more DIY like online resources that people have been gravitating towards. What's your 2 cents on whether or not someone should pursue more of like a DIY estate planning engagement, with themselves and set up their own documents versus hiring, a professional?
Yeah, if you have young children or a sizable estate, more than $1 million, then I think you get the peace of mind knowing that if an attorney who's specifically trained in this type of law and learns about your situation and is going to be available as a resource to your family, I think there's value in paying someone to do your estate plan. So children, larger estate, you want to get some expertise specific to your situation. Like an online resource is great for a modest estate, or if you don't have kids, better than nothing. It's going to do 95% of what you need to do. An attorney is going to get you that extra 5% to make sure everything is covered, and that the little twist in your situation, everybody's situation is different. That little twist that's maybe a little different, we're going to address that. And so, you can usually find an attorney that you can afford. If you have a modest estate, there are attorneys that will give you a break. Ask around. People will give you a flat fee quote. And so I tend to find most people can hire an attorney. If they really can't afford it, then they probably don't have the needs for an attorney. And an online resource is great, and get it done and maybe update it with an attorney in 10 years when you've got a little more of an estate or maybe some more serious situations. But I just ask around, and there are a lot of good attorneys around, and it doesn't have to be that expensive. It doesn't have to break the bank. It really doesn't take that long to get it done. And the peace of mind is worth it, in my opinion, to spend a little money. You only have to do it once. Usually you don't have to keep doing this year after year. You pay for it once, and it should last for a very long time. So do it yourself. Better than nothing, and okay for a modest estate. If you've got several $1 million, I pay somebody to get some help and just make sure it's right and make sure you have a resource for your family. If something goes wrong, you want to be able to call someone to get some help. That's my opinion.
Let's say as a perfect segue, right? If someone is approaching that $1 million level or above, and they know they've been neglecting their estate plan, which 90% of people whose situation I audit, that's definitely one of the financial planning areas that they've neglected. What would be the best ways for them to reach out to someone like yourself and figure out, what is it going to cost me to get my estate optimized?
So for us, we offer people a free first meeting. Just email us or call us, set up a meeting. We'll talk for half an hour. We'll evaluate your situation, discuss what concerns you have and what we need to do. And then at that point, we can give you a flat fee quote. I think a lot of attorneys are doing that nowadays, or they may charge hourly. But you just need to reach out and start the conversation, and then try to get some free info and get a quote or a few quotes from people before you proceed. And that's, it's a people business. That's how it works in this area of the law these days. And, ask your wealth advisor for a referral, ask your CPA for a referral. That's the best way to find somebody, because then they can really give you that personal connection.
Well, I guess as we wrap up, anything else you'd share with the audience before we go?
No, just that the value in hiring a professional such as myself and you, people don't realize you get older, something bad happens. It's nice to have a team, someone that your spouse can call, that your kids can call, that kind of knows what's going on, what to do next. You're not just Googling what to do when someone dies. You already have that team. You're going through the hardest thing of your life, and to have someone help, that's where I see the value in what we do. So it's not just us helping right now when everything's nice and easy and we're just planning for the future. It's nice to have someone on the execution when things do go wrong that can help. That's something that people underestimate, but I see the value there more than anything, really.
Well, it's a great way to end the conversation. Thanks for making time today.
You got it. Good to see you, Chris. Take care.
Yep. Take it easy. Bye.
So huge thanks to Kanoa for sitting down for a few minutes of his precious day to share his insight as to what can make the most sense for particular demographics. Of course, if you have a very unique estate planning situation, like the ones we touched on, but even more complex, it's probably going to make the most sense to enlist the help of an attorney like Kanoa to provide some fiduciary guidance and oversight on your situation. Yes, there might be some costs associated with engaging an attorney. However, number one, those costs can oftentimes be dwarfed by the benefits that you'll reap by engaging. But then two, a lot will host initial phone calls for free or complimentary consultations, and that might give you a better idea as to what ultimately would be in your best interest as far as engaging with a professional or maybe taking a more of a DIY approach. If you have further questions, drop them in the comments below or get in touch on the website. We'll get you squared away. Have an awesome rest of your week, and we'll talk to you later. Bye.